rare and balanced view on politics in today's world. Based on facts, born of rationality, common sense, and logic, providing context on today's events. This is American Perspective with Rick Thomas.
Hello, everyone, and welcome to American Perspective. Ooh, I can still hear myself and the nasally. Woo, everything moved into the nose, it seems, from the sickness. But at least my voice is somewhat back. Somewhat. Anyway. All right. So, yeah, it looks like it's ladies' night over in the Rumble chat. Anyway, so Judge Boasberg, I have no idea where this guy is really coming from. Because to be honest with you, he is, he's not all there. He's not all there. And by that, I mean, he's not paying attention to what's going on around him and what he is supposed to what he's supposed to do. Now, he's a Democrat judge. He's trying to halt the administration's use of the Alien Enemies Act, and got handed down from SCOTUS a decision. We'll talk about that here in just a minute. But yeah, he's ignoring it. He's ignoring it. So yeah. Which, I don't get it. I really don't. But we'll get into it here in just a minute. All right, let's go ahead and get things kicked off. Tonight we have on tap my news for the Pledge of Allegiance. So if you are of mind, please stand, remove your hat if you're wearing one, and follow along with my news as she recites the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic of which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, and of course, I thank you, My News, for that wonderful rendition of the pledge. If you would like to hear your rendition of the pledge played here on the program, all you need to do is record yourself performing the pledge in your style, and then take that audio file, video file, whatever kind of file, attach it to an email, and send it off to me. Send it to fans, F-A-N-S, at AmericanPerspective.online. That's fans, F-A-N-S, at AmericanPerspective.online, and I will get you into the rotation as quickly as possible. All right. So for tonight's headline sponsor, we'll just go ahead and do this. Weak coffee is for the weak. And at Rumble, weak has never been part of the mission. No fillers, no fraud, no settling for mediocrity, just like 1775 coffee. It's single origin, small farm, hand-picked, specialty grade coffee that stands for quality, free speech, and calling out BS when it matters. Forget stale, mass-produced beans, roasted just enough to hide the flaws. Dark roast that hits like a Trump tariff. Medium roast keeps it bold without the bitterness. And of course, the Vitality Mushroom Blend, that gives you real energy and lasting focus with no synthetic garbage. For K-Cup pods, whole beans, or fresh ground coffee, go to 1775coffee.com. That's 1775coffee, all together, all one word, .com. Use promo code STUDIO for 15% off. Once again, go to 1775coffee.com. Use promo code STUDIO and get 15% off all of your K-Cup pods, whole beans, or fresh ground coffee orders. And start your morning with coffee that stands for something. Oh, and by the way, every dollar spent enters you to win a Cybertruck and $30,000 cash. Go to 1775 Coffee. That's the numbers 1775 and the word coffee Stanwood.com. Use promo code STUDIO for 15% off your order. All right. Oof. Oh, all right. Well, Judge Boasberg apparently has now moved to hold Trump officials in contempt, except there's only one problem. SCOTUS has already told him he was the wrong place for this to occur. So he should have, as upon receiving the order from SCOTUS, he should have immediately just dismissed the case out of his court and remanded the case and told the lawyers, yeah, you got to go where SCOTUS told you to go. And he hasn't bothered to do that. He's decided to hang on to the case for some reason. And now he's basically saying that he ruled yesterday that probable cause exists to essentially hold Trump administration officials in criminal contempt after they, quote unquote, violated his orders by continuing deportation flights. Now, this is according to CNN out of the article in Just the News. The ruling follows the Supreme Court determining that Boasberg's court was the improper venue for the case altogether. Yeah, that's the key. Now, Boasberg wrote in his decision, the court ultimately determines that the government's actions on that day demonstrate a willful disregard for its orders, sufficient for the court to conclude that probable cause exists to find the government in criminal contempt. And he tries to make it, like, you gave me no other choice. Because he says, the court does not reach such a conclusion lightly or hastily. Give me a break. He's chomping at the bit to get this done. Anyway, he said, it has given defendants ample opportunity to rectify or explain their actions. None of their responses has been satisfactory. Well, there's only one problem, dude. There's only one big problem. And here, I'm going to go ahead and show you where the problem is. As soon as I get my act together. Which one is it? There it is. Okay. Right here. This is the SCOTUS decision here. In fact, let me scroll up and give you the first. This is Donald Trump, the Supreme Court of the United States, Donald Trump, the president of the states et al. Versus JGG et al. Okay. That's what this is. And they essentially go through the thing. And when you get to, it doesn't even take you to like page 2. And page 2 immediately starts off with, we grant the application and vacate the temporary restraining orders. So his temporary restraining order that he put on to prevent the deportation of Venezuelans and Tren de Aragua gang members, which is what this particular case is about. This isn't about that other dude that El Salvadoran who was, supposedly deported, they claim it's illegally, but he was under a deportation order anyway. But had a hold on it, don't get me wrong, but it was still there. Anyway, here the court, and by the way, this is pretty much unanimous. This was a pretty much unanimous decision on this one, I think. Maybe not. I think it's a 5-4. It might be a 5-4. Anyway, so here it is, right here. They basically say that they grant and vacate the TRO. The detainees seek equitable relief against the implementation and the proclamation against their removal under the AEA. They challenge the government's interpretation of the act and assert that they do not fall within the category of removable alien enemies. Here's the key. But we do not reach those arguments. So in other words, they basically said, no, actually, yeah, you do. You're going to go. So he said they basically make their argument by saying that challenges to removal under the Alien Enemies Act, which, by the way, they rightfully state that it's a statute that largely precludes judicial review. So in other words, the concept of judicial review was suspended with this because of the way that Congress at the time wrote the AEA. And so this entire situation, the statute, is largely precluding judicial review, meaning that the statute is written in such a way that we can't even review it. Okay. And they list a couple of, or they list the case where this came out in 1948. But they also point out that in terms of the challenges to the removals, they have to be brought in habeas, meaning they have to be brought in person. Okay, because remember, habeas corpus means produce the body or whatever, but it has to be done in person. That's what they say. Now, they further come down and say that beyond what was necessary to vindicate due process rights, and having this challenge be in habeas, being in front of them, or in person, regardless of whether the detainees formally request release from confinement, because their claims for relief necessarily imply the invalidity of their confinement and removal under the AEA, these claims fall within the core of the writ of habeas corpus, meaning bringing it again to personally, and thus must be brought in habeas. And they list another couple of cases, Supreme Court cases and court cases that cover this. And so then they continue, meaning SCOTUS, and immediate physical release is the only remedy under the federal writ of habeas corpus. So then they further explain about a capital prisoner, how they may seek to overturn his death sentence in the habeas by analogy to seeking release, and they give a couple of more cases that they refer to with that. But here is where the key is. This is the key, and I'm going to bring it up here. It's highlighted in blue on the screen, and it says, for core habeas petitions, jurisdiction lies in only one district. And they find that that is the district of confinement. And then they state the detainees are confined in Texas. So the venue is improper for the District of Columbia. They also point out, SCOTUS also points out, that as a result, the government is likely to succeed on the merits of this action. I don't know how much clearer they could make it to this judge, okay? But it basically states that, hey, these people need to, first of all, be present in the court. They weren't, because they were detained in Texas, and they apparently didn't make the trip to D.C. But this... This is ridiculous. Now, it continues to continue to talk about this, but they also sort of skirted on the fact that they can't say whether they won't say whether or not the Alien Enemies Act was properly applied or not. But basically, they essentially call out the fact that, well, you know, this isn't your purview. This wasn't where you were supposed to. You're not supposed to do this. And these people have to be in person when they make their claim to get released. And so they pretty much, that's why they rescinded the TRO. Okay? For the most part. So they essentially have told the, they basically have told this judge that, it's, yeah, you're the wrong person to talk about. Now, it goes even further than this. I mean, they're saying basically here in this statement, they're basically saying that, you know, yeah, you were the wrong venue. But it's even more so than just that. Because if you actually read immigration law, in order to do an appeal or affect an appeal, it has to go to what is known as the Board of Appeals, according to the Immigration and Naturalization Act. It's not even supposed to be in district court. So the district court itself is the wrong place to make this case, to appeal these decisions, these deportation decisions. Oh, and by the way, let me explain a little bit more of something to you about this. The immigration courts and the immigration judges, yeah, guess what? They're not actual, like, judges. The judges, quote unquote, that are there, according to the immigration judge, they're basically attorneys that are appointed by the attorney general. They're administrative judges. They're not trial judges. They're not district judges. They're administrative judges. And they're administrative judges that have been appointed as a part of what's called the Office of the Chief Immigration Judge. And they're designed under the Immigration and Naturalization Act to conduct specific classes of proceedings, including hearings. Immigration judges, and this is Title 8 of the U.S. Code, and this is Section 1003.10. If you're interested. But it basically says that immigration judges shall act as the Attorney General's delegates in the cases that come before them. So this is all done under the Department of Justice, under the auspices of the Attorney General. Now, even as a part of the Immigration and Naturalization Act, it continues to refer to the fact that it's the Attorney General who determines, based under direction of the president, who determines who gets deported or not. This isn't even supposed to be a part of the district court system. That was the improper place to even hear this case. Even more so than just the fact that he was in the wrong geographical jurisdiction, it's not even in the correct court system in the first place. It's supposed to be done by the immigration judges and the Board of Appeals as a part of the immigration judges. Now, the Board of Appeals, okay, what is that? Well, they basically, there shall be, and this is in 1003.1, the organization is that there shall be in the Department of Justice a Board of Immigration Appeals, subject to the general supervision of the Director, Executive Office for Immigration Review. The board members shall be attorneys, once again appointed by the Attorney General to act as the Attorney General's delegates in the cases that come before them. So all of this is supposed to be done outside of the judicial system as a part of the executive branch in the first place. It never should have even been heard in the district court system. And if they wanted to appeal a Board of Appeals ruling, then it would go to the Court of Appeals, which is the next level up from the district court. The district court would be cut completely out of this. So Boasberg never should have even taken the case. Never should have even had it because of the geographic restrictions. Because again, as I've said, district court judges, they have their districts and they have their little fiefdoms, but they can't go outside of that. And in fact, I've been discussing with another account on X who keeps saying that, oh yeah, they have full jurisdiction. No, outside of their geographical area, they do not. And so, yeah, this is this is going to be interesting. And the reason why I say it's going to be interesting is because Trump has filed an appeal immediately to counter that federal judge's ruling that there's probable cause to hold it in contempt. So Judge Boasberg issued his rulings, and the Trump administration just sent a request to have it appealed. According to Fox News, the Trump administration's brief appeal to the D.C. Circuit Court does not include any new details, as the facts of the case have already been heard by district and appellate courts. The appellate court last month ruled 2-1 to uphold Boasberg's temporary restraining order. However, the Supreme Court ruled 5-4 that the Trump administration could resume its deportation flights as so long as individuals subject to removal under the law were given due process protections, which, by the way, due process protections basically mean were they given an opportunity to stand up and appeal their case, which is exactly what the immigration courts do. So, and the opportunity to ask for or pursue habeas relief, which again has to be done in person. Yeah. So this is interesting. This is very interesting. Well, so the judge, Judge Boasberg, apparently is hanging on to this whole thing, and is attempting to hold them in contempt of court when he was already told that his venue was the wrong venue for it to even be done in. Yeah. Anyway. This itself is really going to be, this is just the first of many that's going to be interesting to watch. But this has been upheld a couple of different times before too, as to whether or not the Attorney General can, deport people. It's already been upheld 1948, and again in 1953. So, and again, both of those were ordered by the Attorney General. So Pam Bondi, being the fact that she is the one that does the appointments, could potentially, essentially overrule even the Board of Appeals and the immigration judges, attorneys, because they essentially work for her. So, yeah. Anyway. Yeah. They just keep messing up constantly. Well, our buddy, I call him our buddy, our El Salvadoran, got a visit by, of course, Dem Senator, what's his name? Oh, yes, Chris Van Hollen. And he went down there thinking he was going to get him out and bring him home, quote unquote home, except for the fact that he's already home because he's Salvadoran, not a United States citizen. But he's going to have, I think, a little bit of, shall we say, egg on his face here, because there's some new revelations about this particular, about Garcia's young man's history. Yeah, you know, again, the left has like hitched their wagon to this guy. Has hitched their wagon to this guy, and we're now starting to find out some more information about him. So, first off, they have found, very good news outlets, they have found that Kilmar Abrego Garcia had not one but two protective orders taken out against him by his wife, Jennifer Vasquez, for domestic violence. And it's that's the same woman that has appeared in front of TV cameras to, you know, dramatically tell the media that she will not stop fighting until she sees her husband alive. Oh, and by the way, donate to my GoFundMe when you get the chance. Investigative reporter Andy No was the first to uncover a record showing that Vasquez had filed for a protective order against Abrego Garcia back in May of 2021, citing domestic violence as the reason. Well, then Red State dug a little further into Maryland court records. Maryland court records, and uncovered a second protective order filed by Vasquez against Abrego Garcia from August in 2020. So, yeah. He apparently has a couple of protective orders. Now, let's just be honest, okay? Be honest here. Protective orders sometimes can get filed by, you know, there may not have been actual physical violence yet, those kinds of things. I mean, it is possible that they were just in a very rough patch in their marriage and, you know, that kind of thing. But yeah, back then, apparently it was. But there's even one more thing that's being dug up, or that has been dug up by this, with regards to this guy. Tennessee Highway Patrol apparently at one point caught him driving in Tennessee, and this is a report from the Tennessee Star, brought to you by Blaze Media. But a report from the Tennessee Star claims that Garcia was detained in a traffic stop in December of 2022 and was suspected of actual human trafficking. Now, the Tennessee Highway Patrol basically went to the FBI and said, hey, this guy, we're taking photos. First of all, he was driving under let's see, what was it? Hang on. Yeah, so he apparently was driving under a suspended license or something. His license, he was driving without a license in some way. Okay, let's just play that around, and we'll just call it that. But because he was driving with either a suspended or an invalid license, okay, he had 7 other people in the car with him, and the highway patrol, they kind of suspected that maybe he was human trafficking. So the THP, Tennessee Highway Patrol, reached out to the FBI and said, hey, we've got this guy who's got, 7 other people in the car. He's driving under a invalid license for whatever reason, and we think he might be human trafficking. Well, the FBI requested that they take photos of the guy. Oh, Glow is telling me that he had no license. So he didn't have a driver's license. So anyway, he was illegally operating the car. Let's just put it that way. And so the highway patrol reached out to the FBI. The FBI then said, 2 hours later, they said, well, take photos of the 8 individuals and then release them. Let them go. So not that that really means anything. However, it just goes to show you this guy was not like this fantastic father that the left wants you to believe he is. Okay. And even in certain court documents that were presented to the immigration officials, meaning the judges and those kinds of things, there was information on this individual that he was picked up. When he was picked up hanging out at a known gang street corner. He was he basically was caught supposedly or allegedly with some drugs on him, but that he was wearing the same clothes as the gangbangers, and among other things, and that there was at least one credible witness, confidential informant, who had basically identified Garcia, gave them his gang name, and also gave them his gang rank within MS-13. Now, one of the things that you need to understand, too, is that not only did all of this information come to light during the immigration hearing, but when he went in 2019 to basically claim that he needed to keep asylum, it was because of the fact that he had a reason to fear for his life. But the reason that he gave was that another gang was looking to kill him. Now, reports are, and I don't know this for certain, but there are reports that are out there that are basically saying that the gang that this gentleman said was out to kill him is no longer operating anymore in El Salvador. They've been disbanded or something. So his whole reason for being here was because of the fact that he was afraid. And this is, keep in mind, this is back in 2019. We're now in 2025. The old gang was busted up, disbanded. However, it ended up coming to be in that condition. So there's no actual reason, since that's the reason he gave, was that, hey, this other gang is, going to go and try and kill me. But that other gang no longer exists. Therefore, the reason for him being here no longer exists. The reason to keep him here no longer exists. This is a very nuanced case. And both of these cases, of course, are definitely, going to be a challenge to all of this. Now, I will say that there is some confusion between these two cases because the first one obviously has to deal with the Tren de Aragua gang members, the Venezuelan gang members that got shipped off to El Salvador initially. And then the second one, obviously, is this Abrego Garcia. Boasberg is the judge overseeing the Tren de Aragua Venezuelan gang deportations. This other one is the female judge that basically said, yeah, you need to facilitate and, I can't remember the exact wording, but it was very vague that the Supreme Court in their response was, well, yeah, you have to facilitate the return of Abrego Garcia, but we don't understand what this word means. And therefore, what does facilitate mean? It wasn't very clear. And that particular decision was, of course, a 9-0 decision. Now, here's the likelihood, provided that if he actually does get returned to U.S. custody, they basically would fly him home here, have another immigration hearing, and he would immediately get his his stay order revoked because, again, the reason for him having the stay was because of the fact that he was afraid of getting killed by a gang that no longer exists. And so, therefore, he would immediately get returned back to El Salvador. So, yeah. All of this is, all of this is just because of the fact that we have judges, because again, keep in mind that these judges, these district court judges, are the improper venues for where these things are supposed to take place by immigration law. Immigration law states that they need to go to immigration judges, which, as I just explained to you, are appointed by and overseen by Pam Bondi, who is our current Attorney General, and also that it's the Board of Appeals within that same immigration structure under Pam Bondi, the Attorney General. They aren't supposed to hit these district courts. And that's part of the argument in terms of all this. Now, there is a big question because everybody keeps talking about due process. What due process? What kind of due process? Because it's not the same due process that an American citizen has under the Constitution of the United States, because these are not citizens. And in fact, SCOTUS has upheld the fact that the quote-unquote due process is essentially equivalent to the immigration hearing. That's the due process. That's the due process. And it's not as though, in terms of Abrego Garcia's case, as I explained last night, it's not as though he did not get his due process. He got his initial immigration hearing and he got his appeal. So he's been afforded all of the due process that is required by law. He's been afforded all the due process that he needs as required by law. And keep in mind, too, that the Attorney General, because the Attorney General can determine if the individual is dangerous and deport them anyway. Everybody and the mainstream media is all talking about these courts as though they are the specialized court system under what would essentially be Article 3 of the Constitution, such as the lower courts that are created by Congress. And in a way, they are. However, Congress passed off this particular piece under the Immigration and Naturalization Act over to the Department of Justice. In other words, over to the executive branch. And so these immigration judges and these immigration courts all fall under the executive branch by statute. That's where all of this resides, is within the Department of Justice. And so Pam Bondi actually holds the keys in all of this. And as long as they've been given their due process, meaning their immigration hearings, they've had all the due process that they are required to get. It's not the same due process that we as Americans get, because we're Americans subject to the Constitution of the United States. It's not a judicial process. So, anyway. These guys, I'm telling you, this is going to be, well, if nothing else, what I can tell you is that the Trump administration is going to challenge every single one of their things that they can, which, by the way, currently, Trump is actually doing not so bad in his second term. He's nearly undefeated at the Supreme Court level, according to Just the News. And when you think about it, it's actually true. I mean, the whole deportation, the Supreme Court's 9-0 ruling on the matter of Diego Garcia, or Abrego Garcia, I should say, it actually strongly rebuked the lower court judge who ordered his return to the U.S. Because of the fact that, again, it isn't supposed to be part of the return. The Supreme Court actually stayed the deadline originally, added that while the lower court could tell the Trump administration to facilitate his return, the intended scope of the term effectuate, that's what I was trying to remember earlier. The effectuate in the district court's order, however, is unclear and may exceed the district court's authority. See, and again, here it is. It's telling you in this, that one was actually written by Sonia Sotomayor, if I remember correctly, that it very likely that decision has exceeded their authority. See, one thing that is really weird about this entire situation is that the Supreme Court is like going right up to the line of saying, yeah, you know, that really doesn't sound like something that you can do. But they've neglected to take the extra little step to basically say, yeah, you really can't do that. I mean, they're pushing right up to the line. And honestly, this is Chief Justice Roberts. This is what Roberts has got it written all over, because he doesn't want to make policy necessarily from the bench unless it suits him. He wants very narrow rulings that don't alter the policies. And this is one of the ones that that I think there was a little bit of a dissent on this. And there was one recently here where it was talking about, yeah, the district court judges, they really don't have that authority. They don't have the authority to issue blanket stays and universal stays of execution, or of temporary restraining orders and so on and so forth. They can't do that. They're not supposed to. But yeah, even the Sotomayors of the world are saying, yeah, this might be a little bit bigger than what you guys can actually do. It may exceed, this is the term, may exceed the district court's authority. So, U.S. District Court Judge Paula Zinnes is the one who has demanded that the U.S. provide documentation of its efforts to return Abrego Garcia. Okay. Sure, we went down there and we asked. We got told no. There you go. That's pretty much it. And the judicial branch basically has to understand that they have no authority to demand that the government of El Salvador return one of their own damn citizens. That's it. That's all there is. He doesn't belong here, so yeah, we've got no reason to be asking for that. Anyway, we just talked about the whole Alien Enemies Act, which the basically the SCOTUS opinion was that the writ of habeas corpus thus must be brought in habeas, meaning in person, and they said that the deportees do have a right to challenge their removal, but it has to happen where they're detained. They have to be in person to do it, which again, in this particular case, Boasberg, he should have relocated or told them to relocate the case to Texas. So, yeah. But the left isn't going to tell you all that, because to the left, Boasberg is doing their business. No. He's actually ignoring the SCOTUS order. He's actually ignoring it, which makes it really interesting to see what's going to happen on the appeal of this thing. Now, we also forgot, or at least I haven't covered it, but we kind of forgot about the whole mass firing of federal workers. That was allowed by SCOTUS. The panel upheld the original ruling, and the government filed an emergency appeal to the Supreme Court. The original ruling was, of course, that federal departments had unlawfully fired employees, but the SCOTUS immediately blocked the order and allowed the administration to remove the roughly 16,000 employees by placing them on administrative leave. So that was a win. Chief Justice John Roberts handed Trump a temporary win in the permitting him to remove a former National Labor Relations Board member, Gwen Wilcox, and former Merit Systems Protection Board member, Kathy Harris, amid those legal challenges. So there was that. Roberts' move overturned a federal appeals court decision that found Trump lacked the authority to fire those members. But yeah, so both board members had until April 15th in order to respond to the administration's arguments. Roberts has yet to issue a permanent decision right now. In terms of USAID, which we sometimes forget, that came through. USAID, he did have a defeat there. The court ruled 5-4 to require the administration to distribute billions in frozen funds. And of course, keep in mind, that was for contracts that were already completed. Okay. And it's in this decision as when Judge Samuel Alito wrote in dissent, asking the question, does a single district court judge who likely lacks jurisdiction have the unchecked power to compel the government of the United States to pay out $2 billion taxpayer dollars? So they're already considering it. Believe me, they're already talking about, and these justices are already talking about, okay, sooner or later, if things like this continue, they're going to have to answer the question, do lower courts that are created by Congress, have the ability to strap down the constitutionally created and mandated three branches of government? And that's part of the argument that I've had with this gentleman on X, or this person, whoever, this account on X, with regards to this, because The fact of the matter is the lower courts don't have that authority. Now, judicial review does exist. However, it's a very narrow, not a blanket order, and it can only, and the orders that come from these things eventually hit the Supreme Court, and the Supreme Court is the only one that can actually tell the executive branch finally what it can and cannot do. So, yeah. Now, the administration has also, according to this piece in Just the News, the administration has also secured wins at the lower levels to advance its administrative goals. For an example, Judge Vargas relaxed her own previous order to permit DOJ employee Ryan Wunderly to access sensitive payment data from the Treasury Department if he went through the same training that department employees do for handling such data. The 19 Democratic state attorneys general sued to stop DOJ from accessing those Treasury payment systems. DOJ has thus far been able to access those systems, but in February, it's been kind of back and forth, but back in February, District Judge Paul Engelmeyer issued a similar block to it. Reacting to that decision, Musk also identified the need to review payment systems as ranking among the most vital for him to address government spending. So that matter itself could ultimately reach the Supreme Court. But for the time being, it looks like DOJ is not necessarily going to secure full access to the Treasury Department payment data. So it's, it's all across the board though, but most of the wins are coming in, and believe it or not, they're coming in for Donald Trump. Yeah, he is doing things the proper way. It's really going to be interesting to see what happens with all of these court cases. Because again, don't forget too, we still have that whole 14th Amendment deal about birthright citizenship. That hasn't even approached yet on the dockets, but it's out there. It is out there. So we're going to have to see. We're going to have to see what is going to happen. Speaking of illegals and illegal voting, don't forget the SAVE Act got passed in the House. And there was a poll put out by Rasmussen. Now, the Rasmussen poll actually does verify that, well, Americans don't want illegals voting in our elections. Why does that not surprise me? Anyway, so a newly released poll from Rasmussen shows that voters overwhelmingly support preventing non-citizens from participating in U.S. elections. Key word there is prevent, because the law already says that only U.S. citizens are allowed to vote in federal elections. But as I've pointed out on this program multiple times, and I've shown you the proof, illegals are voting in American elections. They are. Anyway, they have already fraudulently cast ballots, and some cases throwing the results off. Well, the SAVE Act requires in-person voter registration and documentation proving U.S. citizenship by showing a real ID, U.S. passport, military identification, birth certificate, among other forms of identification. Okay. Rasmussen followed this up with a national telephone and online survey of a little over 1,000 voters, almost 1,050. and asked the question, how important is it to prevent illegal immigrants from voting in U.S. elections? An overwhelming majority, and I'm not talking like 60-40. I'm not even talking 70-30. I'm talking 75% said that it was important. Rasmussen then asked a second question. Should Congress enact a law requiring proof of citizenship to register to vote in national elections? The results were fairly similar. 64% saying yes, 11% responding not sure. So, yeah. Again, this is one of those 80-20. This is one of those 80-20 things that we've got to have it. We got to have it. Now, 4 Democrats, just for the record, did vote for the SAVE Act. It passed the House vote at 220 to 208. 49% of the House voted against the SAVE Act. Yeah. So, yep. Democrats are not interested, folks. They're not interested in serving you as your constituents. They are only interested in getting the votes, and they think that illegal aliens are going to give it to them. And that's why they are going to El Salvador to try and get a Salvadoran citizen back from Salvador when he never should have been, or El Salvador, when he never should have even been here in the first damn place. But hey, I don't understand it, man. These people are just, they're nuts. They're just totally crazy. All right, folks. Oh, that is it for me for this evening. Do me a favor, if you haven't already, head on over to rumble.com, get yourself an account. It is free. And once you are there, signed up and signed in, make sure you search up the American Perspective channel and hit that green follow button to get notified every time that I go live. Also, too, don't forget to hit those thumbs up and like buttons across all of my platforms, whether it's X, YouTube, Facebook, and, of course, the aforementioned Rumble. We will see you tomorrow night. Hopefully I sound just even a smidge better. We will see you tomorrow night, 5 p.m. Pacific, 8 p.m. Eastern Time, right here on American Perspective. Have a great rest of your evening, and good night, everybody.